Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to another session of the oral argument with the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Lambert, presiding today. Let me introduce the panel. To my right and your left is Judge Carrie Evander, and to my left and your right is Judge James Edwards. We have one case this morning on our docket. It's a criminal case, so each side will have 15 minutes. If anybody in the audience has any type of cell phones or electronic devices, please turn those off or put those on a mute state so that the attorneys are not interfered with by any inadvertent sounds coming from your devices. That being said, if everybody's ready to proceed, we'll start with the one and only case, James Albert Taylor v. State of Florida, case 17-1912.
Good morning, Your Honors, and Steve Gosney on behalf of appellant Mr. Taylor.
Before you start, how much time rebuttal would you like?
Let's say 5 minutes. 5 minutes, sir?
You have to get her approval.
I know, but I'm just saying she's really good, so I'm scared of her. You see.
You want 5 minutes? I'll give you 5 minutes.
Okay, Steve Gosney here with for the appellant.
Okay.
And thank you very much, Your Honors, and may it please the court, counsel. Also, I'd like to introduce Mr. Taylor's parents are in the court. They were sort of through the whole trial and through this whole case. And I'd like to really focus on the oral argument here on point one, although the secondary and third points are supportive, I think, actually, of that point. And I'll touch on that for a second. The allegation, and the key thing to remember in the allegation, what Mr. Taylor was accused of at the trial court, what he was charged with, was at his stepdaughter's bedroom, going into her bedroom, the house that they both lived in, and they'd been living there for about 2 years, goes in there at night, a single swipe of his hand from shoulder to shoulder, lasting mere seconds, over the clothes and over the covers, and then walking out. That's what he's accused of. And for that...
Well, of the breast, not the shoulder to shoulder.
Well, it was a shoulder-to-shoulder swipe, and this is one of the... I think it's...
Well, that's not what he's charged with doing.
He's charged with touching the breast.
Right.
Okay? And, in fact, on the JOA, the court even said, well, based on what he's visualized and saw at the trial, if the touch had been a little bit higher, an inch higher, it would have been not guilty. But instead, because it's an inch lower, it's life in prison. So it's important to understand the context there.
And you say the key issue is whether this momentary touch was the innocent touch of a step-parent doing a bed check versus a lewd and lascivious touch.
Exactly. Now, the question in point one, and the issue that we're bringing to your attention in point one, and we think is constitutional and legal error, is to admit, in this case, into evidence, as Williams rule, that's similar fact evidence, the fact a violent, penetrative rape of an 11-year-old in a much different circumstance.
What testimony was there that it was violent?
Well, when a penal penetration of an 11-year-old on the bed, which she was forced down and then
I'm
penetrated.
asking what evidence. I understand she was forced down and pinned down, but this is not somebody with a weapon. This is not, she goes to the hospital later. It was totally inappropriate if it occurred. Right. But in terms of violent, compared to like the Cotton case, graphic details and all the rest of that.
Right. Well, we do tend to get kind of, what is that? As in criminal law, we see a lot of so when I'm saying violent, I'm saying that the circumstance of a man, a big, strong man, pushing down an 11-year-old and penetrating her with his penis, that is a violent act.
For a blink of an eye, is that what she referred to? A blink of an eye? The penis was inserted for a blink of an eye?
Well,
That's what she said, isn't it? Whether you like it or not.
It was,
is that what she said?
you know, it's tough to refer to the record in this case because, you know, and having, I was also the trial counsel in this, or I was co-counsel. Regina Nunnally was trial counsel. I was co-counsel. And living through the testimony of this case, there were a lot of things that it was kind of all over the map, and part of the problem was pinning down what exactly was being alleged and what they were saying. But also having lived through the Williams rule, that evidence so overwhelmed our case that it just deprived my client of a fair trial.
LG's testimony, that's the Williams rule evidence you just talked about. Did she give any testimony about her breasts being touched, or was it strictly being
She did
forced
not.
down?
She did not. In fact, the judge was trying very mightily to what I call split the baby and say, well, can we have some testimony about some prep work that was done, like some touching that was done prior to the penetration? And he really made extra efforts to try to split that up and say, well, let's not talk about penetration. Let's just see. But the witness just says, no, she comes out, he throws her down, penetrates her with no touching.
Are you talking about the testimony at the Williams rule hearing or at the trial?
At the Williams rule hearing.
Okay.
The judge was trying to kind of split that, but then
At
after...
trial, what happened, what was the trial testimony?
At the trial testimony, she basically just testified when she was 11, 12 years old. She was doing laundry or something like that, and then she comes down and he pushes her down and penetrates her. No prior breast touching or anything like that.
Stuck his penis in her for a blink of an eye is what her testimony was.
Well,
That's her testimony
Well, I
at
understand.
294 and 95.
that was at the trial.
Right.
That's
Well,
what
that's
she
what
said
we're
at
talking
trial.
about.
That's what we're talking about.
Yeah,
Fair
that's what we're
enough.
talking about.
I'm telling that level of a penal penetration, even if it's a blink of an eye, is a capital sex battery. It's a very serious
But
crime.
my question was, there was nothing about touching the chest.
Right. That's right. That's
She
right.
said she was sexually molested, and then she said he stuck his penis in me for a blink of an eye.
Right. That's exactly.
That was basically the extent of her testimony in that context.
And this is where I want to draw the comparison. When you compare the charged offense, which is a sleeping daughter bed check, swipe of the hand over the clothes on the chest area, to a push-down penetration of an 11-year-old, that is so disparate. In all the cases that are cited here, there is no my glasses, sorry. There is no case which has that kind of disparity. They're either equivalent or something less serious. So in this case, we have a much more serious allegation swamping a very, as minor as you possibly can make it, swipe across the chest on the clothes.
You have defense counsel claiming that these three sisters made up everything. She didn't call them liars, but she could see that word from where she was standing. She said, this is a tale from a galaxy far, far away. They made this all up, all of it, to get rid of the defendant out of the household. TF's similar discussion was when she came out of the shower.
Right.
LG's issue was also after she came out of the shower. I mean, it was not corroborative of the charged event, but it was certainly corroborative and similar to TF's collateral event. Why wouldn't that be admissible?
Well, but exactly that. It is not collaborative. LG's testimony is not collaborative of the charged offense.
But the defendant said the defense counsel took the position that they made every one of these incidents up.
Well,
if you're allowed under Williams' rule to corroborate the testimony, not just the testimony, it doesn't limit it necessarily to the testimony of this event, but I mean, the defense counsel took all the girls' testimony about all the incidents and said they were all lies. Why can't you corroborate anything other than the event?
Well, because I think the Williams rule requires it to be, I mean, and the McLean case, I'm sure you're familiar with this, similarity of acts, these are not similar acts, closeness in time, they're not close in time, frequency of prior acts, they're not frequent, and lack of intervening circumstances, there are no intervening circumstances.
They're not frequent if you're not going to let them talk about it. It's more frequent, I mean, and again, the McLean case talks about there's some relaxation of the similarity requirements in a familial setting.
Well, and in fact, it's interesting because the trial court's order allowing in the testimony of LG, that order uses the familial context not only to lower the standard, but then to corroborate. So 'cause you've got a double dipping. Basically, you said, okay, it's familial, therefore we get a lower standard, and it's familial, therefore they're similar. So
McLean did talk about that's kind of the primary purpose in McLean was corroborate, because you basically, in this settings, you don't have other eyewitnesses. And in fact, McLean, when you're talking about the difference in the events, I mean, in McLean, the victim was digitally penetrated once, and the Williams rule evidence, the person had repeated encounters, including penile penetration of the anus. I mean, and they were okay, the Supreme Court ended up okay with that, allowing that Williams rule evidence, didn't they? I mean, I know there's similar type levels of crime. I've tried a lot of these cases.
That's the problem here, is that they are similar. In McLean, you have similar levels of crime.
But much more significant what was going on with the Williams rule witness in McLean, that you would kind of have a visceral reaction to saying, maybe this is a little bit too much, but...
That's true, but the allegations in McLean were equal. Here you have such an equal, and now I want to address, and actually this makes a really good point that Your Honor made, which is that, in defense counsel in our closing, we made a lot of the how do we explain what these girls are saying. Okay, and it's a complicated story to have to explain that. We were required to do that because of the Williams rule testimony, because we had to explain why is this girl making this allegation, and that we were confronted with that, and this goes to point 3, the skunk in the box, which is this testimony, this Williams rule testimony that's thrown out there. It says, oh, well, here's what we're alleged, and we would do these, what do you call it, like moot court sort of things, and we talk to all our friends and neighbors and say, okay, we have this claim, swipe across the chest, and they'd say, that's a good case, and then we'd say, oh, and by the way, what if we told you that, he 2 years before he violently, or he penetrated a 12-year-old, they'd say, oh, he's guilty. In every case, that decides the case. So the due process, we had to explain that in some way. That's why we had to come up with a timeline.
Do you agree, though, that the prosecutor did not make this a feature of the trial? I mean, this was almost innocuous.
Well, and I know that everybody bent over backwards because they're aware of the case law and they were aware of how prejudicial this was. I think the court bent over backwards in their order. They tried to give jury instructions. That the prosecutor didn't make it a feature of the trial, as you say. However, there's no way, and I think it says as a constitutional matter, there's no way that evidence can come into this trial and give my client a fair trial.
So you're saying, basically, if I'm hearing this correctly, you're saying as a matter of law, that can not come in. This is not an abuse of discretion standard. As a matter of law, when you have the dissimilarity between the charged event and this blink of an eye inserting the penis in a 12-year-old, that as a matter of law, that cannot come in. It's reversible error. I mean, that sounds like what you're saying.
Because of the disparity
Right.
between the accusation and the Williams rule evidence. When you say, okay, well, he was, and I don't want to
And you don't have
too
any
much
case
of
that
it.
you don't have any case that says that as a matter of law that when there's that differentiation between the charged crime and the Williams rule evidence or act that it's excludable. It seems like it's a discretionary under 90.403,
Well,
which applies our abuse
but-
of discretion.
giving a fair trial is not a matter of constitutional discretion. Okay,
Well,
if this,
Under 90.403, you got to consider the prejudice factor, and the more serious the crime and the greater the disparity between the Williams rule evidence and the crime, the greater the prejudice. I mean, it's like if you had a murder and a battery, if the battery is Williams rule evidence on a murder charge, it's not that prejudicial.
right,
If you have a murder as the Williams rule evidence on a battery charge, it's extremely prejudicial.
exactly. And I would point you to the federal due process standard also, and that is Scrivney versus Tansey, which is so prejudicial in the context of the proceedings as a whole that he was deprived of the fundamental fairness essential to the concept of due process. And that kind of echoes, just because it is a sex offense, right, doesn't mean it comes in. I don't think that the lower standard means that there's no standard.
The trial judge was very careful to exclude, well, one, there was the allegation of the adult rape, but the victim didn't want to testify. Then you had VT, who had a rape where she was lured away from the school or whatever like that. He excluded that. He did, as you say, try really hard to do as best to find the similarities and to exclude what he could, but as you say, the description with LG, there was really only one event to talk about.
Well, and that's the thing. We could have had a fair trial. This evidence deprived my client of a fair trial, and that's the bottom line.
You have 140 left on your rebuttal, so.
I see the little clock ticking there. But, well, I would look, just because it is discretionary does not mean that it automatically comes in. I think that there is a point at which, like you say, in a battery case, that the Murder-Williams rule swamps the allegation. And that's why point 2 is so important, because this swipe, and that kind of like, this is life in prison, and this is not guilty, this is walk away free.
Well, life in prison also has a factor to do with your client's history too, doesn't it?
That's true. And well, and this is the thing, is it got so complex to have to explain these things, because the reason that these girls made these allegations, I think you've read the trial, was because he gets picked up and the grandpa says, why is he being arrested? Because he failed to register. And then then they start interrogating, well, what happened? Anything happened? Anything happened? And she says, well, he came in one time and swiped here, but I didn't, no big deal. And then later on, when he's about to get out of prison.
Swiped is y'all's word.
What's that?
Swiped is defense counsel's word, not the girls.
Well, that's what happened it's hard with a record like this.
We've
But
all
I
read
mean,
the
this is what
transcript.
happened. Now, if it was lower or higher, that was the whole, we went around and around trying to make it clear for you, because that's what she demonstrated for a moment in time over the close.
You're running out of rebuttal.
Okay, well, thank you very much. I'll
You can do what
come
you
back
want.
in 5 minutes there.
All right.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. Let me be clear that the standard of review here is abuse of discretion. No reasonable person would have let that in. That's what the defense has to demonstrate. And granted, LG's testimony was more sexually intrusive than what happened to the other two
What does the
sisters.
Supreme Court say in McLean? I mean, it says that the purpose of, the trial judge has to ensure that the defendant is convicted based on the evidence of the crime charged as opposed to the Williams Rule evidence. And
Right.
I'm just sitting here, I think looking at the sentence, I wonder if the judge wasn't impacted by the Williams Rule evidence. Because certainly the person hadn't been convicted of a prior sexual battery of a 12-year-old, but he heard this evidence. I mean, and then you look at the evidence in this case, you have a touching, a lewd and lascivious touching of the breast, and then the Williams Rule evidence is a sexual battery.
Well, I think if the older sister Williams Rule witness had gotten up there and cried and said, here's what he did, and he penetrated me, and I ran out of the room, if she had made it graphic or extreme, I think that they would have run the risk of, prejudice outweighing the relevance. But
If you had someone who you found credible, and you said, you asked that person you found credible, do you know Joe Smith? Yes, I do. He's a child rapist. Would you need more than one sentence to make a real point?
Well, I guess that depends on the context. He's being accused of molesting a child, so you already have the ick factor. I mean, the jury's coming in, and this is a serious accusation. I mean, they call it this minor swipe of the shoulders.
I'm going
That's
to call
not
it
what the
touching
kid
the
talked
breast. I'm
about.
going to call it lewd and lascivious touching of the
Right.
breast. But then you have a sexual battery.
You have a very non-graphic, brief description of an incident in the family with a sister at the same age when mom's not available.
They thought it was significant evidence, right?
Well, all the evidence is significant, of course, otherwise we wouldn't introduce it.
This isn't a piece of evidence that comes in by the witness blurting something out.
Right.
Or prosecutor going a little overboard on closing. This was
Right.
a decision made before Williams Rule hearing to put it in, after the Williams Rule hearing to continue to put it in. I mean, you knew it was going to be an appellate issue if there was a conviction. So the state certainly thought this was an important piece of evidence.
The state tried to get in all of the
So this
previous
isn't
sexual
a harmless
batteries.
evidence situation. Would you agree with that?
No, I think it could be harmless, yes. And here's why. Because, first of all, I think it was properly admitted, but I think it could be harmless because you also have the testimony of JF, whose molestation was remarkably similar to what happened to the victim.
That's not on an issue on
That's
appeal.
right, but that's relevant evidence that shows, you compare the strength of the state's case versus what happened here. You also have a strong jury instruction saying you only consider this as it relates to this. You have zero prosecutor overreach.
The Cotton case suggests the fact that you had this Williams Rule evidence from JF shows an even less degree of relevance to have this other evidence.
I think if the defendant molested every single child in the family, I think that's relevant. And if there were 10 girls and he molested all 10 of them, I think you could have put all 10 of them in there. I don't think because that he molested another one that the first one doesn't come in. That's not what the standard is. The standard is if it's relevant, not, gee, the state is kind of piling on here. That's not what the test is. It's as long as it's relevant.
How do you deal with the Fior case where we said that where the evidence was the charged crime was rubbing the vagina, digitally penetrating the vagina, and the Williams Rule evidence, there's two bits, but one of them, two Williams Rule witnesses, one of them I believe was a sexual battery, and we said that we didn't see how that could come in on because we were remanding for a new trial. Didn't see how that would be able to come in again.
I don't have that case with me. I'm not sure if that was in the family context. All of these cases.
It was a neighbor versus a niece.
Okay. So it's not in the family context.
Right.
I think when you look at what the Supreme Court said in McLean about the family, they recognized that this is going to be different because the way these things tend to happen is as the kids reach a certain age, they get molested, and then they age out, and the next one comes up, and they get molested. And the court recognized the defendant's going to have different sexual urges with different kids, that they're not going to be remarkably the same, but there's so much similarity because of the context in which it happens.
Do you think that because you have the JF Williams Rule, did that reduce the relevance or the need for for LG's testimony?
I don't think it reduced anything. I think they're independently relevant. I think the fact that JF testified and was so similar, I think that adds to the harmless error argument. But again, I think if there had been 10 little girls and he molested 10 of them, I don't think you say, well, this is getting to be too much. I don't think that's what the test is.
The defense raised as their defense, as their issue, things surrounding motive,
right,
intent, consent, not so much that she could have given consent to a lewd and lascivious touch, but consent in terms of this was something stepdaddy did all the time. We all understood that he was just checking on it.
Just handsy.
They made that as an issue.
Right.
The defense made the corroboration necessary because they called each story about each incident a lie, didn't they? So
yes,
this,
they
in
did.
terms of the Williams Rule, it all fits into the Williams Rule. The question is whether it's just too much. Is it an elephant gun that shouldn't have been shot?
And I think that this kind of evidence certainly has that potential, and I think they were really, really careful with it. That girl was very vague and brief in her description. It wasn't graphic. It was one of the most innocuous descriptions of a rape that you can have. They read the instruction repeatedly, and the prosecutor, there's so many times where the prosecutor has to go that extra mile and say, see, he's kind of a scuzzbag or something, instead of saying, look, we're focused on what the victim experienced here, and all of this stuff just corroborates it. And this prosecutor was very careful about that.
You said given JF's testimony, that it increases the argument that it's harmless error?
Yes.
Is that because it's cumulative?
That's because it's not just one kid testifying vaguely, and it's a he said, she said. This is a he said, she said, she said. I don't think that changes the relevance.
Well, in Cotton, it changed the relevance when there was already Williams Rule evidence on an extremely similar type of sexual acts. The third DCA said, looked at, that reduces your argument of relevance. It actually
I think at some
suggests that you had
point,
less need for that other
Right.
evidence. And again, in that Cotton case, you had a disparity in the seriousness of the offense, and they found the prejudice, found abuse of discretion.
In Cotton, did each sister testify to multiple sexual offenses?
I don't remember the details of Cotton.
I believe they
Whereas,
did.
whereas here we have 3 sisters, and the only sexual
They talk
abuse
about-
or molestation or anything as to LG was the penetration,
Right, that
correct?
was the only thing she mentioned.
It's not that she testified about a touching and a rape or a sexual
Right.
battery.
It was just the one thing. I mean, they were very careful to limit this. Look, at some point, if you have one touching of a victim and 90 victims coming in, 90 Williams Rule evidence, at some point, it overwhelms the victim's testimony. And in that sense, if you're repeatedly molesting every kid you can get your hands on, at some point it becomes too much, because the Williams Rule overwhelms the actual act that you're focusing on. We're not talking about 10 kids here, we're talking about 2 sisters. And it is similar, and the judge didn't abuse his discretion in finding that. It was the family setting, it was these kids as they reach a certain age, he takes liberties with them. It was at night in each case, it was in the home in each case, mom wasn't around in each case. I mean, there's a lot of similarities. I mean, you have cases where there's female victims and male victims. They're, pretty dramatically different acts. And the court has said that comes
If
in.
the jury did not believe the victim in this case, or had doubts, but believed LG, how great a risk is it in this case that they would say, well, this guy's a bad guy, we need to find him guilty?
I think we have to accept that the jury's going to follow its instructions, and if we think they're not going to, our whole system gets thrown out. And they were specifically told, this is relevant only to show his intent and motive and for these specific Williams Rule thing. They were told that every single time somebody talked about it. The prosecutor said that. There was no overreach at all.
What's the similarity here other than the family relationship?
At night, mom's not home, here's how he has access to him. It's very brief.
Would you agree that most sexual offenses committed by someone in a familiar authority with a minor are not done while a bunch of other people are present?
I do agree with that, yes.
So it's usually going to be alone.
It's going to be alone. That's why there's a relaxed standard, because it's going to be, it's tougher in a
So the
family
fact that
setting.
the fact that it's done while there's no other adult present is not particularly meaningful in determining the similarity, right?
Well, it makes it similar, but they often have that factor, yes, that's very true.
Well, in Cotton, the sexual batteries, the sexual molestation in Cotton occurred in a familial setting. The actual sexual batteries, one of them occurred in a car out in the woods, and the other one occurred in a vacant home. So there were stark differences between the sexual batteries in Cotton versus the sexual molestation in Cotton. Whereas here, you have much greater similarity between
Right.
the sexual battery and the sexual molestation, don't you?
Yes, exactly.
And
The
it's all
fact that it
case-
does occur in the call, and
It's
it's
a
case by
case by
case.
case.
They're all going to be a little bit different. I mean, none of them are going to be exactly the same. And again, the victim also testified about a prior incident with the defendant, and that was pretty darn similar to what happened to LG. Now, he left before it went that far, but, the fact that he's going in that direction, that's all. And again, the test is abuse of discretion. Could the trial judge, because no reasonable trial judge have found that this was relevant. And I think the way they limited
The purpose
it,
is still what McLean says, and that is that the trial judge has an obligation to ensure that the person is convicted for the crime they're charged with.
Right.
And not because of the Williams Rule.
that's absolutely correct, and I believe he did that here, with the jury instructions and with the limited nature of this testimony, and with everybody, including the prosecutor, saying, look, this stuff comes in to show that she's telling the truth, not because he's a bad dude and we want to get him. He made that very clear.
If the defendant hadn't put his penis in LG in the blink of an eye and instead had put his hands on her rear end or her vaginal area, and that was the extent of the one Williams Rule piece of evidence regarding LG, we probably wouldn't be having any discussion about this,
Right.
would we? I mean,
the fact that
in
it is a
essence
sexual
is,
battery, yeah, it is.
does the insertion of the penis in that setting
Right.
and in the context of how she testified it so overwhelm this case that it's a constitutionally unfair trial?
That's
And that gets to
exactly the
whether it's an
question.
abuse of discretion under 90.403 in the context of McLean.
That's
what this case is
exactly
about.
the issue here, yes, and I certainly agree with that. I think, given the fact that it's a family setting and all the similarities, same gender, same age, so, when the opportunity presents itself, he molests them.
So if
In
we're
this
talking,
case,
if we're talking abuse of discretion and the fact that everybody's wrestling with it, does that, under the Canacaris, does that all of a sudden
Right.
all?
I think that
by
indicates that
default-
no reasonable person, I think we have a reasonable disagreement about this, and, there is deference to the trial judge, and that's how it should be, because the trial judge saw her testify. He knew if she was this weeping mess who made a big deal, that the jury would go, oh my God, we have to get this guy, or if she's a matter-of-fact, older child who was very brief and succinct about things. He saw it, he saw the victim testify, he saw the sister testify. That's a lot better than the cold record that this court has, which is why we defer to the trial court in this situation. So we would submit that the trial court did not abuse its discretion. And even if this testimony shouldn't have come in, we'd submit that it's harmless error in light of the fact that he molested these two girls exactly the same way. And the defense was able to say, look, it's this grand conspiracy of the sisters. They all admitted, very frankly, they didn't like this guy. So the jury saw it, the jury decided, based on that instruction, which we have to assume that they follow their instructions, and they were told that you can only consider this in this limited circumstance. So under that, I don't believe that they would convict him because he's a bad guy. They were specifically told what the elements were, and we would ask this court to affirm.
All right,
Thank you.
All right, hang on, counsel,
Thank you, Your Honor.
let me give you,
Can I sneak in?
I'll give you a minute.
A minute? Hey,
Well, you had 20 seconds, so I'm giving you 40 seconds more than you
what
ever
is
used.
this? That's not,
How about that? All right, you ready?
wait, a minute? I thought I had 5 left.
No, you don't get to use,
I don't get to use
you
it.
have 15 minutes, you don't get to use 14 and a half and then say, okay, I get 5 more.
All right. Well, let me make it real quick. I don't think the record says it was at night. I think it was at daytime. Number 2 is, there's a lot of facts. I was there. I was in that trial, and when that evidence came in, the jury changed. It gave us an unfair trial. We preserved this, preserved it. We said to that judge, if you do this, this will be error, and we will be before the 5th. I think it was very clear. We went back at a second time and said it's constitutional dimension. And it is constitutional. And I would also point, Your Honor had brought up Fiore v. State. Is this type of evidence, and I think, Your Honor, Mr. Lambert said very substantially outweighed, a penetration, a vaginal penetration, that substantially outweighs, the unfair prejudice of that is so great that any probative value is substantially outweighed. I just think
If
as
it's
a
a
matter.
discretionary standard and you have a trial judge looking at you right here who doesn't think it's discretionary, abuse of discretion, and then you have maybe another trial judge who says it is, doesn't that by definition or by default under Canacaris mean it's not an abuse of discretion for what the trial judge did here?
It's just, there's no cases that have this kind of dissimilar, this kind of great disparity in allegation versus charged crime, the battery versus the murder example. There is no case that says that that's allowable under Williams' rule. If that is allowable, basically anything, we're convicting people based on who they are rather than what they're alleged. And that's what happened in this trial. I
No,
was there.
that's not what, he excluded 2 that he certainly could have permitted, or at least certainly 1 that he could have permitted.
But I think that he was influenced. In this order, the reason he let that in was because of the allegation of who he was. He's a bad guy. But he did not take every opportunity. He was living in this house with these people for 2 years. And this is an allegation. He comes in and does this one night, during that 2 years. He's not molesting every child every chance he gets. That's not what the record shows.
DF
That's not
said
what
it happened numerous times. She couldn't recall each time. And again, that was defense counsel brought that up.
We were
about whether she was
forced.
asleep or awake or this, that, and the other, and it turned out there were multiple
We were
occasions.
forced to have to defend. You understand, that Williams Rule evidence was coming in, that the court had ruled, so we had to deal with that. So I don't want our closing arguments to be used against us because, well, we brought all this stuff in. We had to deal with that evidence. And that was, it created an unfair trial, Your Honor. We're asking for a new trial.
All right, thank you, counsel.
Thank you very much for, and thank you for really knowing the record.
Okay, we'll stand.